The morning sunlight filtered through the tall windows of the Supreme Court chamber, casting long shadows across the polished wooden benches where America's 9 most powerful judges would soon take their seats. The date was etched in the minds of civil rights advocates across the nation. A Tuesday in late spring, when the court would hear oral arguments in a case that could reshape the landscape of educational equity for generations to come. The gallery had filled hours before the scheduled start time, with people lining up outside the building before dawn to secure one of the limited seats available to the public. Among them were students from historically Black colleges and universities, parents who had fought school board battles in their own communities, retired teachers who remembered when segregation was still legal, and activists who understood that this case represented far more than an abstract legal question. The atmosphere carried that peculiar tension that precedes moments of historical significance. When everyone present senses they might be witnessing something their grandchildren will ask them about decades later. Representative Jasmine Crockett sat in the front section reserved for parties with direct interest in the case, her presence drawing curious glances from those who recognized her from congressional hearings that had gone viral in recent months. She had earned a reputation as someone who did not shy away from difficult confrontations, who prepared meticulously and spoke with a precision that left little room for evasion or misdirection. Today, she was here not as a member of Congress, but as a representative of the legal team that had filed a comprehensive amicus brief on behalf of 17 civil rights organizations, all of whom had standing in this case because their members would be directly affected by however the court decided. If you want to understand how legal battles over equality play out in the highest court in America, and why preparation and courage matter when facing institutional power, make sure you subscribe to this channel because what happened in the next 2 hours would demonstrate exactly how one voice armed with facts and logic can challenge narratives that have calcified into accepted wisdom. The case before the court concerned a challenge to affirmative action policies in public education, specifically whether schools and universities could consider race as one factor among many when making admissions decisions or allocating resources to address educational disparities. The petitioners argued that any consideration of race violated the Equal Protection Clause of the 14th Amendment, claiming that the Constitution required absolute colorblindness in all government action. Their legal team had assembled a formidable array of statistics and arguments designed to show that race-conscious policies amounted to reverse discrimination against white and Asian American students, even when those policies were designed to remedy documented patterns of historic and ongoing inequality. The respondents and their supporting amicus briefs countered that the 14th Amendment had been adopted precisely to address racial subordination, that its framers had immediately established race-conscious programs like the Freedmen's Bureau, and that colorblindness as a constitutional requirement was a recent invention with no basis in the amendment's text or original understanding. The stakes were profound because a ruling against affirmative action would affect not just college admissions but potentially any government program that attempted to address racial disparities in education, employment, housing, healthcare, or any other domain where the effects of historic discrimination persisted into the present. Justice Samuel Alito had telegraphed his views on these issues through decades of opinions and public statements, consistently arguing for what he characterized as a neutral, colorblind approach to constitutional interpretation while simultaneously displaying hostility toward efforts to remedy racial inequality through targeted programs. His judicial philosophy rested on the claim that treating people differently based on race was always constitutionally suspect, regardless of context or purpose, and that the proper remedy for past discrimination was simply to stop discriminating rather than to actively work toward equalizing outcomes that had been shaped by centuries of legally enforced hierarchy. This philosophy had significant rhetorical appeal because it appropriated the language of civil rights while inverting its substance, claiming that true equality required ignoring race even when race continued to determine life outcomes in measurable and documented ways. Critics pointed out that this approach effectively locked in place the advantages that white Americans had accumulated through generations of preferential treatment in education, employment, housing, and wealth accumulation, advantages that did not disappear simply because explicit legal discrimination had ended. But Alito and others who shared his views dismissed such arguments as special pleading, insisting that the Constitution protected individuals rather than groups and that any consideration of race necessarily violated individual rights. The oral arguments began with the petitioner's counsel, a distinguished attorney from a prestigious law firm who had argued multiple cases before the court over a career spanning 3 decades. He opened with a sweeping statement about the fundamental principle of equality under law, arguing that the 14th Amendment established a regime of colorblindness that applied with equal force regardless of which racial group benefited from governmental consideration of race. He acknowledged that historic discrimination had created inequalities, but insisted that the proper remedy was time and equal treatment going forward, not what he characterized as racial preferences that simply reversed the direction of discrimination. His presentation was polished and confident, hitting rhetorical notes that had proven effective in previous cases and that resonated with the conservative majority's stated commitment to originalist interpretation and limited government power. Several of the conservative justices nodded along as he spoke, occasionally interjecting with questions that seemed designed to reinforce rather than challenge his arguments. Justice Alito, in particular, appeared engaged, leaning forward in his chair and making notes on the pad before him. When the petitioner's counsel concluded his opening statement and the floor opened for questioning, Alito was among the first to speak, his voice carrying the authoritative tone of someone accustomed to having his views treated as definitive. His question was directed at the respondent's counsel but framed in a way that presumed the answer, asking whether the attorney seriously maintained that the government could allocate educational opportunities based on skin color and still claim to be treating citizens equally. The phrasing revealed his underlying assumption that any acknowledgement of racial difference in policy necessarily constituted unequal treatment, collapsing the distinction between discrimination designed to subordinate and policies designed to remedy subordination. The respondent's attorney attempted to explain that context mattered, that the 14th Amendment had been understood by its framers to permit race-conscious remedies for race-based harms, and that decades of Supreme Court precedent had recognized this distinction. But Alito interrupted repeatedly, his questions growing more pointed and his tone increasingly skeptical. He cited snippets from previous opinions, mostly his own or those of justices who shared his views, treating them as settled law even when they represented contested interpretations that commanded only narrow majorities. He questioned whether any racial disparities in educational outcomes actually resulted from ongoing discrimination rather than from individual choices and cultural factors, a line of argument that implicitly blamed marginalized communities for their own disadvantage while ignoring systemic barriers. The exchange became increasingly tense as Alito pressed his vision of colorblindness as constitutional mandate, and the respondent's attorney struggled to respond to questions that seemed designed less to elicit information than to establish a record supporting a predetermined conclusion. That was when the Chief Justice, perhaps sensing that the oral arguments were becoming too one-sided or perhaps responding to a subtle signal from one of the amicus representatives, recognized that there was a request to address a point of factual context that had arisen during Justice Alito's questioning. The protocol was unusual but not unprecedented, as the court occasionally allowed amicus participants to clarify specific factual matters when the justice's questions revealed misunderstandings or gaps in the record. Jasmine Crockett rose from her seat with the same composed determination that had characterized her previous appearances before congressional committees and in courtrooms across Texas. She approached the lectern without hesitation, placed her materials down with deliberate care, and looked directly at Justice Alito. The courtroom seemed to collectively hold its breath because everyone present recognized that they were about to witness something rare, a direct engagement between a sitting Supreme Court justice known for his rigid ideological commitments and an advocate who had already demonstrated her willingness to challenge power with facts and logic. When she spoke, her voice was clear and controlled, carrying the confidence of someone who had spent countless hours preparing for exactly this moment. and who understood that preparation was the foundation of effective advocacy. Justice Alito, she began. You have asked several questions premised on the assumption that considering race in educational policy necessarily constitutes discrimination against individuals based on skin color. I would like to address that premise directly because I believe it rests on a fundamental misunderstanding of what these policies actually do and what the Constitution actually requires. The affirmative action programs at issue in this case do not allocate opportunities based solely or even primarily on race. They consider race as one factor among dozens in a holistic review process that evaluates each applicant as an individual. The distinction matters because your framing suggests that these institutions are engaged in crude racial sorting, when in fact they are attempting to build diverse educational environments that benefit all students by exposing them to perspectives and experiences they would not otherwise encounter. She paused, letting that initial point register, then continued with increasing specificity. You have also suggested that any consideration of race violates equality principles, but that claim ignores the actual history of the 14th Amendment and the intentions of those who drafted and ratified it. The same Congress that passed the 14th Amendment also established the Freedmen's Bureau, which provided race-specific assistance to formerly enslaved people in the form of education, healthcare, and economic support. Those congressmen did not believe they were violating the equality principles they had just enshrined in the Constitution. They understood, as we should understand, that remedying the effects of racial subordination sometimes requires acknowledging race in order to transcend it. Justice Alito straightened in his chair, his expression shifting from patient attention to something more guarded and defensive. He interjected with a question clearly designed to regain control of the exchange, asking whether Crockett was seriously arguing that the 14th Amendment authorized racial discrimination as long as the government claimed benevolent motives. The phrasing was calculated to make her position sound absurd, equating efforts to remedy inequality with the very discrimination that had created inequality in the first place. But Jasmine had anticipated this exact rhetorical move because it was a standard technique in conservative legal argument, the false equivalence that treated all considerations of race as morally and legally identical, regardless of context or purpose. Her response was swift and devastating in its logic, delivered with the kind of precision that comes from having thought through every possible objection and prepared answers that were both legally sound and accessible to anyone listening. "No, Justice Alito," she said, her tone remaining respectful but firm. "I am arguing that the 14th Amendment prohibits racial subordination, not that it prohibits any governmental awareness of race. Those are fundamentally different propositions, and conflating them requires ignoring both the text and history of the amendment. The amendment guarantees equal protection of the laws, which means protection against systems and practices that subordinate people based on race. It does not require governments to pretend that race does not exist or that centuries of racial hierarchy have left no ongoing effects that might require remedial action." She continued before he could interrupt again, building her argument with careful attention to both legal doctrine and empirical reality. The distinction between subordination and remediation is not just semantic, it is constitutional bedrock. When governments used race to exclude Black students from educational opportunities, they were violating the 14th Amendment because they were subordinating a group based on racial classification. When governments now consider race as one factor in admission decisions in order to ensure that educational institutions serve diverse communities and provide equal educational opportunities that were historically denied, they are fulfilling the amendment's promise rather than violating it. The purpose matters, the context matters, and the effects matter. She gestured toward the stack of materials on the lectern before her, materials that contained studies and statistics that her team had carefully compiled and vetted. The record in this case shows that race-neutral alternatives have been tried and have consistently failed to maintain the diversity that creates educational benefits for all students. The record also shows that students of all races benefit from diverse educational environments, developing stronger critical thinking skills, greater cultural competence, and better preparation for functioning in a diverse democracy and workforce. Those are not abstract or ideological claims. Justice Alito. Those are findings from rigorous social science research conducted over decades and reviewed by experts across the political spectrum. Alito leaned forward, his voice taking on an edge that suggested he felt the exchange was not proceeding as he had expected. He asked whether Crockett believed that educational benefits justified racial discrimination, framing the question in a way that again presumed the conclusion by labeling affirmative action as discrimination. But Jasmine refused to accept his framing, and her refusal was itself a form of argumentation because it forced the court and everyone listening to confront the question of how we define discrimination in the first place. Justice Alito. She responded, "The term discrimination implies treating people worse because of their race, imposing burdens or denying benefits based on racial classification in ways that subordinate or stigmatize. That is not what is happening in these programs. No student is being denied admission solely because of their race, and no student is being admitted solely because of their race. What is happening is that institutions are making individualized decisions that take into account the full range of what each applicant would contribute to the educational community, including but not limited to the perspectives they would bring based on their racial and cultural backgrounds. If we are going to call that discrimination, then we have evacuated the term of any meaningful content and made it impossible to distinguish between policies that subordinate and policies that include." The courtroom had grown completely silent except for the sound of her voice and the occasional scratch of pens as journalists and law students frantically took notes. Several of the justices who had seemed disengaged during earlier portions of the argument were now paying full attention, and even those who likely disagreed with Crockett's position appeared to recognize that she was forcing them to grapple with their reasoning in ways that scripted oral arguments rarely achieved. Justice Alito, however, seemed determined to reassert his framework, and his next question revealed both the depth of his commitment to colorblindness ideology and perhaps something more personal, a frustration at having his premises challenged so directly. He asked, with barely concealed irritation, whether there was any limiting principle to her argument, whether the government could engage in racial classifications indefinitely into the future based on claims that disparities reflected historic discrimination. It was a familiar conservative talking point, the suggestion that any acknowledgement of ongoing racial inequality would lead to permanent racial preferences with no clear endpoint, essentially locking in a system of reverse discrimination that would never be dismantled. Jasmine Crockett's response to this question would become the most widely quoted and analyzed portion of the entire oral argument, the moment when her logic and preparation crystallized into a statement so clear and forceful that even her opponents would have difficulty dismissing it. "Yes, Justice Alito," she said, "there is a very clear limiting principle, and it is the same principle that has always governed equal protection analysis. The government's use of race must be narrowly tailored to achieve a compelling governmental interest, and it must be necessary because less restrictive alternatives are inadequate. Those requirements already constrain what governments can do, and they provide the limiting principle you are asking about. When racial disparities no longer exist, when educational opportunities are genuinely equal, regardless of race, when students from all backgrounds have the same access to the resources and experiences that prepare them for selective institutions, then race-conscious policies will no longer be necessary to achieve diversity and equal opportunity. The limiting principle is reality itself, the empirical fact of whether inequality persists. Right now, it persists. The data is overwhelming and undeniable, and so remedial policies remain necessary and constitutional." She leaned slightly forward, her voice gaining intensity without losing its measured quality. "But I want to address what I think is the deeper concern underlying your question, which is whether acknowledging race in policy creates a slippery slope toward permanent racial classification. The answer is no, and history proves it. The Freedmen's Bureau did not operate in perpetuity. It was time-limited and ended when Congress determined it was no longer necessary. The various race-conscious programs that have been implemented over the past 60 years have evolved and changed as circumstances changed. This is not an either-or proposition where we must choose between pretending race does not exist and permanently organizing society around racial categories. It is a pragmatic question about what tools are necessary at any given moment to achieve genuine equality, and it requires looking at facts rather than abstractions. She paused, and then delivered the observation that would be replayed and quoted countless times in the days and weeks that followed. The irony, Justice Alito, is that the color blindness you advocate for would itself be a form of permanent racial classification, because it would permanently lock in the advantages that white Americans accumulated during centuries when the government very explicitly considered race in allocating opportunities, resources, and rights. Refusing to remedy that history does not make you neutral. It makes you complicit in maintaining its effects. The impact of that statement was immediate and visible. Justice Alito's face flushed slightly, and for several seconds he appeared unable to formulate a response. Other justices shifted in their seats, some looking uncomfortable while others seemed to be processing the implications of what they had just heard. The silence stretched long enough that the Chief Justice felt compelled to intervene, asking whether any other justices had questions for Miss Crockett before her time expired. Justice Sotomayor immediately spoke up, asking Crockett to elaborate on the empirical evidence regarding the ongoing effects of historic discrimination, a question that allowed Jasmine to walk through specific studies and statistics that demonstrated persistent disparities in educational resources, college preparation, and opportunities despite decades of formal legal equality. She cited data on school funding disparities, on the concentration of experienced teachers in predominantly white versus predominantly minority schools, on differences in access to advanced coursework and college counseling, and on the cumulative effects these disparities had on college admission outcomes. Each statistic was delivered with precision and tied directly back to the legal question of whether race-conscious remedies remained necessary to achieve genuine equal protection. Justice Kagan followed with questions about how the educational institutions in question actually implemented their admissions policies, giving Crockett the opportunity to dispel misconceptions about racial quotas or mechanical point systems. She explained that holistic review processes considered race as part of a broader assessment of what each student would contribute to the educational community, that these processes involved individualized evaluation rather than group preferences, and that the goal was not to achieve specific racial percentages but to ensure that classes included students from diverse backgrounds who would challenge and learn from each other. Justice Kagan then asked whether there was evidence that these diverse educational environments actually produced better educational outcomes, and Jasmine walked through multiple longitudinal studies showing that students who attended diverse institutions demonstrated stronger analytical skills, greater ability to work across cultural differences, and better preparation for leadership roles in diverse societies. She noted that even students who opposed affirmative action as a policy matter often acknowledged benefiting from the diversity it helped create, suggesting that the educational benefits were real even when the means of achieving them remained controversial. Justice Alito eventually recovered enough to ask a follow-up question, but his tone had changed, becoming more defensive and less certain. He asked whether Crockett was accusing the court of being complicit in discrimination, a question that revealed he had taken her earlier comment personally rather than as a legal argument about institutional effects. Jasmine responded with careful precision, making clear that she was not questioning anyone's personal motivations but rather pointing out that legal doctrines have consequences regardless of the intentions behind them, and that a doctrine of color blindness in a society where racial inequality persists will necessarily perpetuate that inequality, whether or not that is anyone's goal. She emphasized that this was not about individual blame but about institutional responsibility, about whether the court would use its power to dismantle systems of inequality or to preserve them under the guise of neutrality. Justice Alito did not ask any further questions after that exchange, instead, sitting back in his chair with an expression that observers would later describe as somewhere between frustrated and resigned. The look of someone whose preferred framework had been systematically dismantled and who had no clear path to reassembling it within the time constraints of oral argument. The remainder of the session continued with questions from other justices, some hostile and some sympathetic, but the dynamic had shifted in fundamental ways. The conservative justices who might have joined Alito in pressing a color blindness framework seemed more cautious, perhaps recognizing that Crockett had identified weaknesses in that position that would be difficult to address in a written opinion that would face scrutiny from historians, legal scholars, and the broader public. The liberal justices built on the foundation Crockett had established, asking questions that highlighted the tensions and contradictions in treating all racial classifications as equivalent. When the oral arguments finally concluded and the court adjourned, the immediate reaction was electric. Journalists rushed to file stories with headlines like "Crockett challenges Alito's colorblindness framework" and "Representative dismantles conservative justices' logic." Legal commentators across the ideological spectrum acknowledged that something unusual and significant had occurred. Even those who disagreed with Crockett's positions admitted that she had forced the court to confront difficult questions that had often been glossed over in previous affirmative action cases. Social media erupted with clips and commentary, with many users expressing surprise that such direct challenges to Supreme Court justices were possible and praising Crockett for refusing to be intimidated by the setting or the power dynamics. Within hours, multiple hashtags related to the exchange were trending nationally, and news networks were devoting significant segments to analyzing the legal and political implications. Conservative media outlets criticized Crockett's intervention as inappropriate and accused her of trying to intimidate the justices, while progressive outlets celebrated it as a necessary corrective to a court that had become increasingly disconnected from the realities of ongoing racial inequality. But even critics had to acknowledge that her arguments had been substantive rather than merely rhetorical, grounded in constitutional text, history, and empirical evidence rather than emotional appeals or partisan talking points. Several prominent conservative legal scholars published pieces arguing that while they disagreed with Crockett's conclusions, she had raised legitimate questions about whether color blindness doctrine adequately accounted for the ongoing effects of historic discrimination, questions that deserved more careful engagement than they typically received in conservative jurisprudence. The academic response was similarly intense, with law professors assigning the transcript as required reading and using it to illustrate fundamental debates about constitutional interpretation, the role of social science evidence in legal reasoning, and the relationship between formal equality and substantive justice. Several scholars noted that Crockett had effectively deployed originalist arguments, pointing to the race-conscious programs implemented by the same Congress that passed the 14th Amendment, which complicated conservative claims that the Constitution required colorblindness. Others focused on her use of empirical evidence to demonstrate that race-neutral alternatives had been tried and found inadequate, which addressed the narrow tailoring requirement that even supporters of affirmative action sometimes struggled to satisfy. The exchange also sparked broader discussions about who gets to participate in Supreme Court proceedings and whether the court's traditional insularity from direct democratic input served or undermined its legitimacy. Some argued that allowing more diverse voices in oral arguments, including elected representatives with expertise in areas being adjudicated, could improve the quality of judicial reasoning by forcing justices to confront perspectives they might not otherwise encounter. Others worried that this would politicize the court further and undermine the independence that allowed it to protect minority rights against majority will. Behind the scenes, sources familiar with the court's internal deliberations reported that the justices had unusually contentious discussions about the case in the weeks following oral arguments. According to these accounts, Justice Alito had been particularly vocal in his criticism of how the hearing had proceeded, arguing that allowing Crockett to speak had created an unfair dynamic and that her arguments had been designed more for public consumption than for serious legal analysis. Other justices reportedly pushed back, noting that Alito's own questions had invited the kind of response Crockett provided, and that the court could not insulate itself from accountability by limiting who could point out flaws in its reasoning. The substance of Crockett's arguments had apparently also generated serious discussion, with some justices acknowledging that the historical evidence regarding the 14th Amendment's original understanding was more complicated than colorblindness doctrine acknowledged, and that the empirical evidence regarding persistent disparities and the ineffectiveness of race-neutral alternatives was stronger than they had previously recognized. Whether these discussions would ultimately affect the outcome remained unclear, as the court's conservative majority had shown itself willing to overturn established precedents and ignore evidence that contradicted its preferred conclusions. The decision, when it finally came several months later, was indeed a victory for the petitioners, with the court's conservative majority ruling that race-conscious admissions policies violated the Equal Protection Clause. Justice Alito joined the majority opinion and wrote a separate concurrence that attempted to respond to some of the arguments Crockett had raised, though legal scholars noted that his responses often restated his conclusions rather than grappling with the evidence and logic she had presented. He insisted that the Freedmen's Bureau was distinguishable because it addressed the immediate aftermath of slavery rather than ongoing effects decades or centuries later, though he did not explain why that distinction should matter constitutionally or how one determined when remedial policies were no longer justified. He dismissed the social science evidence regarding educational benefits of diversity as insufficiently rigorous and too contested to justify what he characterized as racial discrimination, though he applied no similar skepticism to claims that race-neutral alternatives could achieve similar benefits despite evidence to the contrary. Most tellingly, he did not directly address Crockett's point about colorblindness locking in historic advantages, instead simply asserting that the Constitution required equal treatment going forward regardless of past inequality. The dissenting justices, led by Justice Sotomayor, cited Crockett's arguments extensively and praised her intervention as having laid bare the logical and empirical weaknesses of the majority's position. The dissent walked through the historical evidence she had presented, the empirical studies she had cited, and the fundamental contradiction she had identified between claiming to promote equality while refusing to remedy inequality. The dissent also noted that the majority opinion had failed to explain how its colorblindness requirement could be squared with the original understanding of the 14th Amendment, instead relying on more recent precedents that themselves rested on contestable interpretations. Legal historians would later note that the dissent's engagement with originalist evidence and social science research set a new standard for how challenges to conservative jurisprudence could be framed, combining the methodologies that conservatives claimed to value with evidence they found difficult to dismiss. The dissent's citation of Crockett's arguments also ensured that her intervention would remain part of the permanent record, available to future advocates and future courts that might be more receptive to her reasoning. In the immediate aftermath of the decision, Jasmine Crockett spoke at a press conference organized by the coalition of civil rights organizations she had represented. She acknowledged disappointment with the outcome but emphasized that the fight was far from over, that the decision would face implementation challenges and political pushback, and that the arguments she had articulated would continue to resonate in public debates and future litigation. She noted that Supreme Court decisions were not final in any ultimate sense, that they could be overturned by subsequent courts or rendered obsolete by constitutional amendments, and that the history of civil rights in America was a history of defeats that eventually became victories through sustained organizing and advocacy. She also pointed out that the oral arguments had achieved something important even if they had not changed the immediate outcome. They had forced a public reckoning with the logical foundations of colorblindness doctrine and had demonstrated that conservative jurisprudence rested on contestable claims rather than neutral principles. Millions of Americans who had watched or read about the exchange now understood that debates over affirmative action were not simply about following the Constitution, but about choosing which interpretation of the Constitution to follow, and that choice had consequences for who would have access to educational opportunities and economic mobility. The longer-term impact of the confrontation extended well beyond the immediate case. Jasmine Crockett became a prominent voice in discussions about Supreme Court reform, testifying before Congress about proposals to add justices, impose term limits, or create mechanisms for democratic accountability. She argued that the court's increasing willingness to overturn precedents and impose contested interpretations without regard for empirical evidence or practical consequences demonstrated a need for structural changes that would make the judiciary more responsive to the values and needs of the place. Democratic majority. Her arguments drew on her experience challenging Justice Alito, using that confrontation as an example of how lifetime appointments allowed justices to ignore evidence and logic without facing meaningful accountability. She noted that Alito had been unable to defend his position when directly challenged with facts and constitutional history. Yet his vote still counted equally with those of justices who engaged more seriously with evidence, and he would continue exercising that power for as long as he remained on the bench, regardless of how poorly his reasoning withstood scrutiny. Educational institutions affected by the ruling scrambled to develop new approaches to achieving diversity without explicitly considering race, and many looked to Crockett and her legal team for guidance on how to frame these efforts in ways that might survive future legal challenges. She worked with university administrators, admissions officers, and civil rights lawyers to develop strategies that addressed the socioeconomic factors that correlated with race, that considered applicants' experiences overcoming adversity and discrimination, and that evaluated how students would contribute to diverse learning environments without using racial classifications as explicit criteria. These workarounds were imperfect and often less effective than straightforward race-conscious policies, but they represented attempts to preserve some measure of diversity and equal opportunity within the constraints the court had imposed. Crockett emphasized that these technical solutions were only temporary measures, that the ultimate goal remained changing the legal landscape through new appointments, new litigation, or constitutional amendment, so that institutions could once again explicitly address racial inequality rather than having to work around judicial prohibitions. The confrontation also inspired a new generation of lawyers and advocates who saw in Crockett's example the possibility of challenging entrenched power through rigorous preparation and fearless advocacy. Law school applications from students of color increased in the years following the oral arguments, with many applicants citing Crockett's intervention as motivation for pursuing legal careers focused on civil rights and social justice. Legal clinics and advocacy organizations reported surges in volunteer interest and donations, as people who had watched the exchange wanted to support efforts to continue the fight Crockett had embodied. Her approach of combining technical legal expertise with accessible explanations and moral clarity became a model for how advocates could engage with complex constitutional questions while maintaining connection to the communities and values that motivated their work. She demonstrated that effective advocacy required not just understanding doctrine and precedent, but also being willing to challenge the assumptions underlying that doctrine, to insist that courts ground their reasoning in facts rather than abstractions, and to refuse deference to power when power was being used to perpetuate injustice. Years later, when historians and legal scholars assessed the affirmative action jurisprudence of this era, many would point to the Crockett-Alito exchange as a pivotal moment when the weaknesses of colorblindness doctrine were exposed with unusual clarity. While the immediate outcome had favored opponents of affirmative action, the intellectual foundations of that victory had been shaken in ways that made future reversals more likely. Crockett had planted seeds that would grow into more sophisticated legal arguments, more effective organizing strategies, and eventually perhaps a return to constitutional interpretation that took seriously the ongoing project of achieving genuine racial equality. The confrontation had also demonstrated something crucial about how change happens in democratic societies. It requires people willing to speak uncomfortable truths to power, armed with facts and logic and moral conviction, refusing to be silenced by institutional authority or procedural niceties when fundamental rights are at stake. That lesson extended far beyond debates over affirmative action to encompass every struggle for justice and accountability, every moment when ordinary people must decide whether to accept the world as elites have constructed it, or to demand something better. If watching Jasmine Crockett systematically dismantle Justice Alito's reasoning made you think about how legal arguments shape who gets opportunities and who gets left behind, make sure you hit that subscribe button and turn on notifications, because these battles over equality and justice continue every day in courtrooms and legislative chambers across America, and we will keep following every development that determines whether this nation finally lives up to its founding promise that all people are created equal and deserve equal protection under law.